This might be the most staggeringly corrupt thing that any president has ever done, and it's not even close. This isn't hyperbole. President Trump is selling access to himself and the White House to the largest purchasers of his own worthless meme coin. And the worst part is, all of this might be legal. Yes, President Trump is no stranger to monetizing his presidency for financial gain. He's sold the public everything from Trump-branded polyester pajamas to Mar-a-Lago pickleball paddles to, most recently, merch promoting the violation of the 22nd Amendment. So what is there left to sell when you've already peddled salvation to the masses and the scent of winning? Well, how about direct access to the leader of the free world himself? In a move that one senator has denounced as, quote, the most brazenly corrupt thing a president has ever done, President Trump's meme coin website has offered a night to remember to the largest investors in the Trump meme coin. Specifically, the site advertised that the top 220 holders of the Trump coin will be invited to an exclusive dinner with the president in May at his private members-only club in Washington, D.C., with the top 25 holders receiving the special perk of a, quote, ultra-exclusive private VIP reception with the president, including a separate, quote, special VIP tour of the White House. Self-designated as the, quote, most exclusive invitation in the world, the promotion blatantly publicizes the private and direct access to the president that awaits the highest bidders. The site enthuses that, quote, you are having dinner with the president of the USA. Invitees will enjoy a, quote, intimate private dinner with the president and, quote, hear firsthand from him about the future of cryptocurrency. And the meme coin team posted on Twitter the, quote, this is real, in the room, shoulder to shoulder with greatness. And if Trump's goal was to increase the price of the meme coin, which he's no longer bound by any lockup rules so he can sell whenever he wants, well, the plan seems to have worked. The announcement set off a dystopian game of hungry hippos, with Trump holders scrambling to buy the digital asset in unprecedented amounts to secure a seat at the table with the commander-in-chief. The value of the meme coin, which I'll remind you is completely worthless, surged over 50% in the immediate aftermath of the dinner news, boosting its total market value to $2.7 billion. Now, I think we can all agree that this blatant self-enrichment scheme is cringeworthy and unbelievably corrupt, but is it legal? And if not, is there any way to hold Trump accountable for selling access to the president to the highest bidder? Now, in case you didn't know, shortly before his second inauguration, Trump launched a meme coin called Trump. Meme coins are a subset of digital assets that use blockchain technology and derive their value largely from internet culture and memes such as Dogecoin and Fartcoin, rather than any underlying utility or asset. They can be traded without using a bank as an intermediary, and the nature of this, or any cryptocurrency, allows pseudonymous investments, meaning anyone in the world can buy the Trump coin without revealing their identity. Now, since its launch, the meme coin has earned Trump and his business partners about $41 million in fees and $312 million in sales of the coin. At its January 19th peak, a Trump token went for $75.35, but has plummeted ever since, losing 88% of its value until now. On April 23rd, Trump's meme coin website announced a private gala dinner scheduled for May 22nd, 2025 for the top 220 holders of the Trump coin at the Trump National Golf Club for an opportunity to, quote, hear firsthand from the president about the future of crypto. The announcement also promised the top 25 investors in the meme coin, quote, an ultra-exclusive private VIP reception with the president, as well as a, quote, special VIP tour. Only the biggest and most important Trump coin holders will win this honor. The winners would be determined by how much of the coin contestants own, as well as how long they hold it between April 23rd and May 12th. The contestants' promoters have created an online leaderboard to rank the anonymous accounts, known only by their crypto wallet addresses and usernames. Now, the announcement sent the crypto world into a tizzy, with buyers pouring tens of millions of dollars into the Trump coin since the announcement launched. The promotion caused Trump coin to jump by more than 50% and hit a peak of $14.32 that afternoon. The holders of 27 crypto wallets have since acquired more than 100,000 Trump coins, stakes worth about $1 million each. And according to the Washington Post review of the crypto data, the largest buyer acquired 2 million Trump coins worth about $24 million on the heels of the announcement. Taken together, these 27 wallets acquired over 8 million Trump coins worth about $100 million in total. Now, the two organizations that own 80% of the meme coin supply, CIC Digital LLC, an affiliate of the Trump Organization, and Fight 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 LLC, led by Trump friend and entrepreneur Bill Zanker and co-owned by CIC Digital, also profit based on how frequently the coin is traded. And through such exchanges, the team has earned about $1.3 million in fees over the ensuing week. Now, not one to shy away from conflicts of interest, I'll remind you that President Trump did not divest from his ownership interests in his various properties before taking the presidency again. And on top of that, Trump has been overseeing the regulation of the crypto industry, from which he is, at the moment, profiting. After opposing digital assets during his first term, Trump pivoted during his 2024 campaign to champion the cryptocurrency industry, which donated tens of millions of dollars towards his re-election. And after taking office, Trump appointed cryptocurrency advocate Paul Atkins as SEC chair and tech investor David Sachs as crypto czar to oversee cryptocurrency policies. In January, Trump issued an executive order supporting the expansion of the cryptocurrency industry and promoting U.S. leadership in digital assets. In February, the SEC issued guidance stating that meme coins do not qualify as securities and will not be subject to oversight by the agency, effectively shielding the crypto market from regulatory scrutiny. On top of that, in March, Trump announced a Bitcoin strategic reserve and digital asset stockpile, which will apparently include other digital currencies. And most recently, on April 7th, Deputy Attorney General Todd Blanche issued a memorandum entitled, quote, Ending Regulation by Prosecution, Eliminating the Justice Department's Crypto Fraud Prosecution Unit. And this memo aligns with a broad administrative effort to scale back white-collar crime enforcement, marked by a freeze on Foreign Corrupt Practice Act cases and the high-profile pardons of executives involved in crypto-related financial violations. Now, critics are denouncing the dinner contest as an unusually explicit attempt to monetize presidential access, with one insider calling it, quote, a race to the bottom for presidential grifting. A spokesperson for the nonpartisan ethics watchdog group Crew called the dinner invitation, quote, as unethical as you can get, essentially selling off access to the president and the White House. And the ethics director at the Campaign Legal Center has characterized the dinner contest as, quote, an unprecedented ethics breach. Of course, in the past, people have bemoaned selling off access or the appearance of selling off access in return for donations to campaigns. But this is one step further. This is direct patronage of a business owned by President Trump. And Trump's offer of exclusive access to top investors in the Trump coin prompted Senators Adam Schiff and Elizabeth Warren to demand an immediate probe to determine whether President Trump's actions violated federal ethics rules. In an April 25th letter to the U.S. Office of Government Ethics, the senators wrote, quote, this latest action raises grave ethics and legal concerns, including the severe risk that President Trump and other officials may be engaging in pay-to-play corruption by selling presidential access to individuals or entities, to include foreign nationals and corporate actors with vested interests in federal action, while personally enriching the president and his family. The letter explains that the offer of presidential access in this manner may implicate federal bribery statutes and the emoluments clauses of the U.S. Constitution. Quote, it also raises the troubling prospect that foreign actors are using the meme coin as a vector to buy influence with President Trump and his associates without needing to disclose their identities publicly. Finally, the senators emphasized that, quote, the American people deserve the unwavering assurance that access to the presidency is not being offered for sale to the highest bidder in exchange for the president's own financial gain. And while the Office of Government Ethics can issue recommendations, it has no authority to prosecute ethical conflicts involving a sitting president. And with the White House and both chambers of Congress under Republican control, and with a new ethics director appointed by Trump himself, the Warren Schiff letter is likely to be the political equivalent of screaming into the abyss, which I highly recommend right now. Now, if you're not the president of the United States and you try to bribe a federal official, you're probably going to want a good lawyer. But if you want a great lawyer, let my law firm, the Eagle Team, help. If you've gotten in a car crash, suffered a data breach, especially if you got one of those data breach letters saying your information might have been leaked, or dealing with a workers' comp or social security issue, we can represent you or help find you the right attorney. And by the way, we don't get paid unless you do, so there's nothing up front. So just click on the link in the description or call the phone number on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team. So this is embarrassing, it's undignified, it's unpresidential, but is it illegal? Well, the answer is a resounding it depends. Critics of the crypto dinner contest have pointed out that investor purchases of the Trump coin to secure a private audience with the president could violate the Constitution's emolument clauses. Senators Warren and Schiff directly reference this possibility in their recent letter, urging a probe into the ethical minefield of the crypto dinner. And the emoluments clause is basically the Constitution's anti-corruption provision designed to safeguard the president's independence and protect against others trying to influence their decision-making through the giving of emoluments, benefits, advantage, or profit. So first, the Foreign Emoluments Clause, Article 1, Section 9, Clause 8, prohibits the president from accepting any, quote, present, emolument, office, or title of any kind, whatever, from any king, prince, or foreign state, absent congressional consent. An emolument is basically any payment, salary, fee, or benefit someone receives from holding an office or employment. So basically, under this clause, the president can't accept anything of value from a foreign government without congressional approval. The Domestic Emoluments Clause, Article 2, Section 1, Clause 7, provides that, quote, the president shall receive for his service a compensation which shall neither be increased nor diminished during the period for which he shall have been elected, nor shall he receive any other emolument from the United States. This means that Congress can't tinker with the president's salary in an attempt to influence him, and the president can't receive benefits other than his compensation from federal or state governments, with or without congressional consent. Now, taken together, these clauses were designed to ensure that the president's decisions were free from domestic and foreign influence, and that he doesn't put his own personal interests ahead of the nation. But it is open for debate whether a violation of one of the emoluments clauses is a crime or just an impeachable offense. But it's hard to argue that the May 22nd crypto dinner is anything other than a potential emoluments clause violation just served up on a silver platter. You can basically draw a straight line between the increase in the value of the crypto coin and the value of the businesses, some of which are directly owned by the president. And as explained in the letter sent by Senators Warren and Schiff, one leading Trump investor with a stake exceeding $13 million is registered with a crypto exchange founded in China. Several other heavy investors have reportedly received funds from Binance, a crypto exchange that does not allow US customers. And if any of these foreign investors are government agents, you'd likely have a violation of the Foreign Emoluments Clause. And as explained by American Democracy Minute, quote, "It's not the price of the coin that should worry Americans, but the corporations, special interests, or foreign governments could exploit the crypto dinner offer as an opportunity to channel money to the notoriously transactional Trump in exchange for access and favors." Now, the speculative nature of crypto coins probably shouldn't have much bearing on whether their purchase could be considered emoluments clause violations, as Trump's bottom line has already benefited through the trading fees alone. But Trump's attorneys would probably rely on the speculative nature of meme coins to argue that they are a legal gray area, giving him carte blanche to disregard the emoluments clause prohibitions. And on top of that, I'm sure that Trump's legal team would also likely stick to their previous position that the term emoluments is narrow and doesn't apply to, quote, private business transactions untethered to the president's official duties, such as the payment of ordinary fees for a hotel room or a market fee for services or other business interests. Now, those arguments were made in the context of a Trump-owned hotel in Washington, D.C. during Trump's first administration. And that makes more sense in the context of a real going concern like a hotel, though it's definitely not a dead winner, and there are certainly some real ethical problems with Trump owning that hotel during his first presidency. But in this case, there are some facts that make it potentially much worse. Number one, the meme coin was launched just days before Trump took office. Number two, it has no real value in and of itself, unlike a going concern like a hotel. And number three, the things that people are buying are not the ability to stay in a hotel room offered by a hotel, but rather seemingly direct access to the president. On top of that, Trump may also feel emboldened by the fact that those with power to restrain him under the traditional system of checks and balances doesn't seem to be standing in his way. And in fact, the president is controlling the Department of Justice. And unfortunately, the Supreme Court didn't really clarify anything during the emoluments clause cases during Trump's first term. You might recall that multiple lawsuits allege that he violated the emoluments clauses by profiting from foreign and state government spending at his hotels and businesses. That situation raised new questions about whether a sitting president could be held accountable for financial conflicts of interest tied to his private enterprises. And unfortunately, the Supreme Court slow-walked that litigation so that the cases remained unresolved by the time he left office, when the court dismissed the cases as moot. Other cases faced standing challenges, which effectively led to the same result: no decisions on the merits. But apart from emoluments, Trump's meme coin gambit could amount to more than just an emoluments clause violation. It could amount to federal bribery. And even Ethereum founder Vitalik Buterin has warned that political meme coins are, quote, vehicles for unlimited political bribery, including from foreign nation states. Under 18 U.S.C. 201, a public official commits bribery where he or she, quote, directly or indirectly corruptly demands, seeks, receives, accepts, or agrees to receive or accept anything of value personally or for any other person or entity in return for A, being influenced in the performance of any official act. Now, there's an open question whether this law applies to the president. Some people maintain that generally applicable laws apply to the president. Some say that the laws do not apply to the president unless specifically called out. And there's also the question of whether the president is an official that applies under this law. And of course, that doesn't even deal with the immunity issues, which we'll talk about in a second. But this particular offense of bribery contains 5 elements. 1, a public official. 2, who accepts. 3, anything of value. 4, corruptly and with the intent to influence. 5, an official act. Now, on top of that, what qualifies as an official act is its own can of worms, according to the Supreme Court. As they've explained, quote, bribery requires intent to influence an official act or to be influenced an official act. In other words, for bribery, there must be a quid pro quo, a specific intent to give or receive something of value in exchange for an official act. And with this narrow reading, the elements of corrupt intent for an official act are especially difficult to prove. Corrupt, for the purposes of the statute, has been interpreted as, quote, incorporating a concept of the bribe being the prime mover or producer of the official act, and an official act, in turn, is a decision or action on a, quote, question, matter, cause, suit, proceeding, or controversy. And in a case that we've talked about a lot on this channel, in McDonald versus the United States, the Supreme Court held that a Section 201 official act has 2 components. 1, the public official must make a decision or take an action on 2, something specific and focused that is pending or may by law be brought before a public official. With respect to the first component, McDonnell explained that a, quote, decision or action may include using one's official position to exert pressure on another official to perform an official act, or to advise another official, knowing or intending that such advice will form the basis for an official act by another official. And as for the second component, the McDonnell court explained that the matter, proceeding, or controversy must, quote, involve a formal exercise of governmental power that is similar in nature to a lawsuit before a court. Such formal exercises of governmental power would include agency proceedings or hearings before a committee on which a decision is made or action taken by the public official. And conversely, the mere acts of setting up a meeting, talking to another official, or organizing an event would not in and of themselves constitute an official act. So here, the crypto dinner, especially the VIP tour and special meeting with the president for the top 25 Trump investors, is rife with potential bribery violations, though such violations would be challenging to prove. Trump's acceptance of the financial benefits from the top meme coin investors and agreement to influence an official act on their behalf, such as the dismissal of a government investigation or a favorable outcome in a pending hearing, would certainly qualify as an unlawful quid pro quo in violation of the statute, but it would be much harder to prove under the Supreme Court's rubric that just meeting with these top investors as a prize qualifies as an official act of the president. The argument would be that anyone can meet with anyone that they want, regardless of whether they're president or not, and thus it wouldn't qualify as an official act of the president qua president. But Section 201 also prohibits the lesser offense of giving and accepting gratuities, and the statute's anti-gratuities provision prohibits a public official from directly or indirectly receiving or accepting anything of value personally, quote, for or because of any official act performed or to be performed by such official or person. The difference between bribery and the acceptance of gratuities is one of intent. Unlike the provision prohibiting bribery, the anti-gratuities provision does not require proof of intent. It merely prohibits the acceptance of anything of value for or because of an official act. And the Department of Justice has explained that a bribe says please, while a gratuity says thank you. But the penalty for violating the anti-gratuities provision is a fine and/or imprisonment for no more than 2 years. At this point, some of you may be wondering what's the difference between the upcoming crypto dinner and campaign events selling high-dollar seats to rub shoulders with a political candidate. Well, for better or worse, it's pretty standard for politicians to have fundraising dinners with top campaign donors. In fact, on April 24th, Trump hosted a $1 million per plate campaign dinner fundraiser at the same Trump National Golf Club, where the May 22nd crypto dinner will take place. Now, notwithstanding the constitutional limit on a third term in office, Trump hosted the $1 million per head fundraiser to raise funds for MAGA Inc., the Super PAC. Now, a Super PAC is a political action committee that can accept unlimited contributions and spend an unlimited amount of money supporting or opposing federal election candidates, but cannot directly donate money to a candidate or coordinate with the candidate's campaign. This is in contrast to a regular PAC, a political committee that can donate directly to candidates, but is subject to contribution limits. Now, since his January inauguration, Trump has hosted at least 3 such mega-dollar dinners at Mar-a-Lago to raise funds for the MAGA Super PAC. And as political fundraisers, these dinners are subject to oversight by the Federal Election Commission, or FEC. Now, the FEC is an independent agency that oversees enforcement of laws specified under the Federal Election Campaign Act. Now, the upcoming crypto dinner has been very careful to avoid styling itself as a political fundraiser and to ensure that it's not classified or affiliated with a political campaign, most likely to circumvent the FEC requirements. So, as we discussed, that creates its own, criminal bribery issues. But the meme site did proclaim that, quote, neither the Trump memes nor the services are political and have nothing to do with any political campaign, government agency, or governmental office in the United States of America or elsewhere. It further states that it, quote, is not political and has nothing to do with any political campaign or any political office or governmental agency, and that President Trump is appearing at the dinner as a guest, not soliciting any funds for it. Though that's interesting because the Supreme Court has granted wide immunity for the president with regards to official presidential acts, and those disclaimers would probably be pretty good evidence that these are not official acts of the president. And another interesting aside here is that the crypto dinner's original invitation, released on April 23rd, promised VIP tours of the White House to the top 25 investors. And soon afterwards, the site removed references to the White House and is now merely promising a special VIP tour with no tour location specified. But either way, I worry there's a sort of criminal whipsaw here where the bribery statutes require an official act, but if it is an official act, then it would be covered by presidential immunity. And if these aren't official acts of the president, then the immunity doesn't attach, but then it doesn't meet the requirements of the federal bribery statute. This is going to be a mess. And yes, thanks to last year's Trump versus United States decision, presidents are entitled to presumptive immunity from prosecution for their official acts. So it is only a vanishingly small number of acts that Trump could be liable for related to an emoluments clause or anti-bribery statute. So at base, a lot of this is only remediable through impeachment. We've talked about impeachment a lot. The impeachment clause, Article 2, Section 4 of the Constitution provides that the president shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. And as you can see, bribery is explicitly listed as grounds for impeachment, which some have argued to mean that the president is not liable for the general bribery statute. It is only remediable through impeachment. And impeachment has been recognized as a proper remedy for a violation of the Emoluments Clause. In Federalist 65, Alexander Hamilton wrote that impeachment exists for, quote, offenses which proceed from the misconduct of public men and involve, quote, injuries done immediately to the society itself, and violating a constitutional safeguard against foreign or domestic influence, especially by personally profiting from the presidency, seems to fit that definition. On the other hand, Senator John Ossoff recently weighed in on the crypto dinner controversy, telling a Georgia town hall that, quote,
when the sitting president of the United States is selling access for what are effectively payments directly to him, there is no question that that rises to the level of an impeachable offense.
But with a Republican-controlled House and Senate, that's obviously basically off the table. On the other hand, at least one politician has proposed a bill taking aim at the president's meme coin. In February, Representative Sam Liccardo of California introduced the Modern Emoluments and Malfeasance Enforcement, or MEME Act, which would prohibit the president, vice president, members of Congress, senior executive branch officials, and their spouses and dependent children from issuing, sponsoring, or endorsing a security, future, commodity, or digital asset. The legislation would subject violators to criminal and civil penalties, including disgorgement, and would prohibit efforts to further profit from an asset issued before the bill's enactment. And to circumvent presidential immunity bestowed by Trump versus United States, the bill makes clear that prohibited financial transactions under the act would be deemed beyond the scope of official duties. Although it's up to the judiciary, not Congress, to define what is and is not an official duty. But recognizing that this bill has no chance of passing in the Republican-controlled Congress, Representative Liccardo said that the bill should serve as a placeholder for when Democrats come back to power, as well as an important symbolic gesture against what he called obvious corruption. But all is not lost in a sea of politics. The anti-bribery statute also imposes liability on those that offer bribes to public officials. So someone could be found liable for attempted bribery or successful bribery, where they gave money to an official with the intent to influence official action in exchange for the donation, irrespective of whether the official actually accepted the donation, was aware of the donation, or ultimately took any action whatsoever. So a future Democratic president could prosecute Trump buyers intending to seek specific favors, like an official VIP White House tour, even where Trump denies being influenced or even aware of these buyers. So in the end, if there is another Democratic election and the political will, the most exclusive invitation in the world might end up being a one-way ticket to prison. So anyone planning on bribing the president is probably going to want to protect their online privacy, which they can do by signing up for today's sponsor, Incogni. And while it doesn't work on the blockchain, Incogni removes your personal data from online data brokers by reaching out directly and forcing them to take your personal info down. If these data brokers resist, Incogni will take care of that too, because Incogni fights back. And for a limited time, you can use my link in the description with the code LegalEagle for an exclusive 60% off discount. And Incogni just launched a new feature called Custom Removals for subscribers to their unlimited plan that I think is really cool. It allows you to flag an unlimited number of sites where your data is exposed, and you can even have Incogni's privacy experts review and tackle the most uncooperative data brokers and people search sites. Because these data brokers are the reason why in the US you can search your name and find a bunch of websites that will give anyone your home address, phone number, and extensive history. It's shocking just how easy it is to find all this information. It also might be why you're getting so many spam calls lately, or how someone might even steal your identity. And Incogni is a great way to take back control of your data, increase your online privacy, and cut down on those annoying scam calls and emails that used to flood my voicemail and inbox. I've been using Incogni for years now, and in that time, you can see I've been on hundreds of lists, some of which had a high sensitivity score, meaning the broker had tons of data on me. Luckily, Incogni has completed hundreds of takedowns for me over the years and is processing dozens of others as we speak. If I were to try this myself, it would take hundreds of hours, so thank you Incogni for saving me weeks of my life and adding me to over 40 suppression lists. And Incogni will continue to conduct ongoing removals, because even if the broker removes your data once, they can collect it again. Incogni makes sure that your personal information stays off the market for good. So if online privacy is important to you, give Incogni a try. If you click on the link that's on screen or down below, you can try Incogni risk-free for 30 days and get a full refund if you're not into it. But if you do decide to keep it, you'll still get the exclusive 60% off discount, so long as you use my link or the code LegalEagle, all one word, at checkout. So after you sign up for Incogni, click on this link over here for more LegalEagle, or I'll see you in court.